Hello, folks. Welcome to my channel, A State of Affairs. I am California attorney Ryan Casson. Please like my channel, subscribe to my channel. Let's dig in. I'd like to spend a few minutes talking about what I might call recent lessons from the courts in the asset protection litigation arena. I have three recent cases. So, what is working and what is not working? And is this really a surprise? So, we have, first of all, folks, Huckabee. Let's call these three cases the Huckabee case on this CES 2007 trust out of Delaware. And third and finally, we have In Re Samatos. And I apologize if I am mispronouncing that last name. So, Huckabee and the Delaware case are similar in the sense that the trust makers, the transferors, they transferred real estate or real property. But these can easily be contrasted in what sense? So Huckabee involved co-trust makers, co-settlors, again, California residents, transferring California real property. I believe it was a parcel of real estate in the Tahoe area on the California side of the border, not Nevada. However, these California trust makers transferred their California real property to a Nevada asset protection trust. In Huckabee, these settlors, the two trust makers, they were also the beneficiaries and the trustees. Generally, when you set up a domestic asset protection trust or DAPT, or simply asset protection trust in an asset protection state such as Nevada or South Dakota or Delaware, you are going to be using and appointing a trustee in that state. So in Huckabee, it would have been, and I think should have been, a Nevada trust company, for example, and not the trust makers themselves. And they were also beneficiaries. So in contrast, in this Delaware case, the second case, that trust maker did create a Delaware asset protection trust, but that trust maker did not transfer the real estate to the trust. That trust maker had several parcels of Michigan real estate. So in contrast to Huckabee, the Delaware Asset Protection Trust settlor in the CES 2007 trust case transferred the parcels of Michigan property, Michigan real estate, to LLCs. And the Delaware Asset Protection Trust was a 90% member of the LLC, and two separate South Dakota trusts comprised the remaining 10% membership interest in the LLC. So in contrast to Huckabee, where the trust makers transferred or deeded California property to a Nevada trust, in the second case, this Delaware trust maker transferred title to the Michigan properties to LLCs. And the LLC members were certain trusts, including in particular this Delaware Asset Protection Trust, which the Delaware Court of Chancery upheld as a valid, permissible, appropriate Delaware Asset Protection Trust that was validated and functioned as it was designed to do to this point. So the creditor challenging the asset protection nature of the trust in Delaware lost. In contrast, in Huckabee, and by the way, interestingly, in Huckabee, the creditor challenging the Huckabee Nevada Trust was the IRS. But don't get too hung up on the fact that it was the IRS challenging the trust. I think the result would have been very likely similar, and the same result in Huckabee had the creditor been an entity or any creditor other than the IRS or any other tax agency. The fact of the matter is, in Huckabee, they should have been utilizing the Nevada resident trust company or some type of corporate trustee. Generally, it's not going to be an individual in many instances, but it should be in that state where the trust is set up and managed for the day-to-day affairs. Same thing with South Dakota, where I'm licensed. If we were to set up a South Dakota trust, we would almost certainly, especially for asset protection purposes and South Dakota law, and I believe similarly in Nevada, we would use a South Dakota trust company. And it's interesting that in Huckabee, the settlors were the beneficiaries. For asset protection purposes, that generally is not how these trusts are designed, where the trust maker is not a resident of that asset protection state. So I think had the Huckabee trust makers been Nevada residents, the result could have been drastically different. And that is a very important point, folks, in considering potential trust designs and estate planning. And perhaps, asset protection may be one factor of your comprehensive overarching estate plan. But you need to remember the laws in the trust designs are potentially drastically different for state residents versus residents of other states. So again, in Huckabee, they were California residents, not Nevada residents. So again, by way of simple analogy, if we were to set up a South Dakota domestic asset protection trust or a similar trust that would be the asset protection trust. And I've talked about this in a prior video, the SLAT, the spousal lifetime access trust. Perhaps one spouse transfers their separate property to that South Dakota SLAT, that South Dakota spousal lifetime access trust with the other spouse or their spouse, whoever the spouse may be from time to time, or the children. They would be the beneficiaries. So the trust maker would not be the beneficiary. So Huckabee was apparently designed in contrast to that. The Huckabee Trust was designed in contrast to this customary framework. So also, folks, the fact that we're talking about real estate is extraordinarily important. So again, in Huckabee, the judge in California, a federal district court judge for the Eastern District of California, had no problem. It was not difficult for that judge, and this is explained in that court's opinion in Huckabee. For interpretation and construing the trust, the judge said Nevada law would apply. But in terms of assessing the spendthrift nature of the trust or the anti-alienation provisions of the trust says the beneficiary cannot, convey or burden or mortgage or encumber, etc., the trust property. The court found in Huckabee, California law is what applies to analyze that question. Can the spendthrift clause be upheld? Again, in Huckabee, had they been Nevada residents, I suspect the spendthrift provisions in the Huckabee Trust would have been upheld. And we're kind of getting into the weeds, folks. I recognize, in specifically, I'm using this word spendthrift trust. What is a spendthrift trust? As I alluded to a couple minutes ago, certain states, certain jurisdictions, such as Nevada and South Dakota and Delaware and Alaska, allow state residents to create self-settled spendthrift trusts. So self-settled means you are settling or creating the trust yourself and you are a beneficiary. And you have a spendthrift clause or spendthrift provision that says no creditor can attach, no creditor can reach the trust contributions, the property in the trust. But for that to work, you need to be a resident of that state. So the Huckabee trust makers would have needed to have been Nevada residents, which they weren't. So the spendthrift clause is a very important component that can be challenged, particularly where we're talking about real estate that's not even located, right? It's not that hard to understand that in Huckabee, the California property was in California. If the California real property is in California, it's not in Nevada. So the judge allowed the creditor to essentially pierce that spendthrift protection and reach and attach the trust assets because California law does not allow for self-settled spendthrift trusts. And the court found that's essentially what the Huckabee settlors created. Again, not to belabor that point, I think the result would have been different had they been Nevada residents, and especially as well, and this is no small point, had they used a Nevada resident trustee. So the CES 2007 trust out of Delaware is a very interesting contrast, right? Because at first blush, it's similar in the sense that Michigan property, Michigan real estate is being transferred to an asset protection trust created in an asset protection trust jurisdiction. The trust maker's Delaware trust, right? He created a Delaware asset protection trust. But again, and this is the nuance, and this is very important, and had the Huckabee trust makers followed the CES 2007 Delaware framework, maybe the result would have been different. Maybe. But the trust maker in this Delaware case transferred the title to the Michigan real properties, the Michigan real estate, to LLCs. That is not a transfer to the irrevocable trust. The trust maker, the property owner, did not transfer the Michigan real estate to the Delaware Asset Protection Trust. The trust maker, or I should say the homeowner, the real property owner, deeded the Michigan parcels of real estate to the LLCs. And the LLC members included the Delaware Asset Protection Trust and, again, 2 South Dakota trusts. So the transfer of the Michigan real estate to the LLCs under Delaware law essentially effectively recharacterized the Michigan real property into personal property. So the Delaware trust didn't even own the real estate. The Delaware Asset Protection Trust owned in a personal property LLC interest. And inside the LLC was the Michigan real estate. So this is a very common estate planning and asset protection technique. Again, it would have been very interesting had the Huckabee trust makers followed this structure instead, because in that case, the Huckabee trust makers would have had the Nevada Asset Protection Trust as a member of perhaps one or more Nevada LLCs. And perhaps there would be another trust that would have rendered the Nevada LLC into a multi-member LLC, as in this second case, the Delaware case. So perhaps they could have done in Huckabee the Nevada LLC and the Nevada Asset Protection Trust could have been a 90% owner, and then there's some other trust in Nevada or South Dakota, perhaps, that could have owned the remaining membership interests in the LLC. And the California real property could have been transferred or deeded to the LLC. So I think those of us in the estate planning and asset protection space are still kind of eager to see how a judge is going to rule on that type of fact pattern. Unfortunately, Huckabee did not afford the judge that opportunity, and the IRS was able to get into that trust and put their hands into that cookie jar. Whereas in the Delaware case, that case was upheld. That trust was upheld. So there are some lessons to be learned in terms of respecting formalities of the state and just basic estate planning and asset protection concepts at this level, at this estate planning level. You need to stick with the program. Maybe in another video, folks, we can talk about the interesting nuance regarding the transfer of property to an LLC rather than an irrevocable trust can help mitigate the fraudulent transfer claims, which the Delaware Chancery Court noted it could not even do because there was no transfer to the trust. That trust maker transferred the Michigan title to the real estate to LLCs. And then, in fact, transferred it in and out a couple times, which is interesting. But that was not those were not transfers in and out of the Delaware Asset Protection Trust. The real estate titles were being transferred in and out of the LLC. So third and foremost, and this can certainly be a full, 30-minute or perhaps 1 hour video on this third case, in re Samatas, just in a couple minutes, folks. The summary in Samatas is the debtor in Samatas was actually a trust beneficiary of a trust share that he inherited. The Samatas debtor, he had his father. His father had created this trust, and the debtor was the trust beneficiary that unfortunately found himself having to file for bankruptcy in bankruptcy court in Illinois. And that's where this interesting litigation spun out of. It was the Chapter 7 bankruptcy trustee in Illinois who was seeking access to the Samatas Trust. So as in Huckabee, the Samatas discretionary trust contained a spendthrift provision. So let's think back. What does that spendthrift clause traditionally do? It works its effect, and it should bar and prohibit creditors from putting their hands in the cookie jar. A valid, enforceable spendthrift clause would ordinarily, traditionally, prevent and prohibit even a bankruptcy trustee from trying to claw the trust property out of that trust and into the so-called bankruptcy estate. When you file for Chapter 7 bankruptcy, I believe the Samatas case, by the way, originated and started as a Chapter 11, but was then converted into a Chapter 7 that was, rather complicated due to certain factors that were at play in the adversary proceeding, which is a lawsuit in bankruptcy court. We call those adversary proceedings or adversarial proceedings. But a valid and enforceable spendthrift clause should prohibit the trustee from clawing the trust property out of the trust and into the bankruptcy estate. Here in Samatas, though, the bankruptcy court ruled that Chapter 7 trustee, was permitted to do that. The Samatas bankruptcy judge collapsed and pierced the spendthrift clause. So again, in contrast to Huckabee and this Delaware case, the Samatas debtor did not set up this trust, right? He was not the settlor. He was not the trust maker. He simply inherited a a nice amount of funds. The court's opinion, talks about, millions of dollars. So cutting to the chase, conduct matters and actions matter. And frankly, how you set up your trust matters for your beneficiaries. So apparently the Samatos father, he did set up this trust as a so-called discretionary trust, a discretionary spendthrift trust, where the trustee would have discretion to make distributions to the beneficiary, including no distributions at all. If that trustee decided that for some reason the beneficiary should not be getting distributions, such as if there was a lawsuit, that is in the sole discretion of the trustee. That ordinarily affords excellent asset protection, creditor protection for the trust beneficiary. Except in Samatos, in my reading of the court's opinion, and of course I would direct you folks to all of these opinions. These opinions control. I'm simply sharing what I can take away from these opinions. Apparently, the Samatos debtor, the bankruptcy petitioner, he was rather involved, let's say, in the goings-on with the trust. In fact, he was a co-trustee, and he was the investment trustee, which was split, or sometimes we use this interesting word, or the roles were bifurcated. So there was an accountant who was the distribution trustee. And the trust in Samatos stated that the debtor, the beneficiary, he had no say in trust distributions. The co-trustee was the sole distribution trustee. So nevertheless, there was this whole back and forth with expert testimony and witnesses. It's really, really interesting about whether these distributions from the Samatos Trust were loans. So if they're loans, you would think that that beneficiary, the debtor, would need to pay them back. And that's a whole nother layer that would have to be handled in bankruptcy, right? Where all creditors need to be listed, all amounts due to creditors need to be listed. And if there's a $10 million loan from the trust that the beneficiary needs to pay back, arguably that $10 million loan needs to be listed. But that was made all the more complicated and all the more complex because of this relationship between these co-trustees and who knew what, why were certain things done, where are the books, in who's on the bank statements. There's references and there's this apparently from the court's opinion, the beneficiary had at least one trust bank account in his name. And why was that not in the name of the trust, and et cetera, et cetera. So there were some very complex and interesting factors and a lot of testimony as to who had dominion and control. So at the end of the day, there was such a combination of access, a unity of access and control, that the judge said, you know what, this trust beneficiary has exclusive and effective dominion and control, even though allegedly on paper, in writing, he's an investment trustee and has no say in distributions, although there were cash outflows, and maybe we're not calling them distributions, we're calling them loans, or et cetera, et cetera. The judge said, no, this individual, this beneficiary, who is also wearing a hat essentially as a partial trustee and investment trustee, and due to, again, certain factual presumptions that the judge made, due to the evidence, the judge said the spendthrift clause is inapplicable and can be pierced under Illinois law because the bankruptcy debtor and the trust beneficiary, the same person who's also the investment trustee, had, exclusive and effective dominion and control. And it also resulted in the court agreeing that the alter ego theory applied, where the trust was an extension of the bankruptcy debtor, the bankruptcy petitioner, the trust beneficiary. The trust was, an extension of himself or alter ego, and he did make contributions to the trust. But one of the factual questions was, were these contributions that really were intended to be just contributions to a trust that you didn't even create, or were these loan repayments? And that triggered a whole bunch of, factual questions with, well, if they were loan repayments, what does the paperwork show, and where is the paperwork, and how are these noted on the books, and the internal affairs of the Summitas Trust. If you're paying down loan principal or you're paying down interest, you would think that the trustees would keep the appropriate paper trail, perhaps electronically. So the judge saw through all of this and also found that in addition to the spendthrift clause being pierced, in which allowed the bankruptcy Chapter 7 trustee to claw the trust property into the debtor's bankruptcy estate, the judge also agreed on the second theory that the alter ego theory was applicable, and that the trust, in fact, was the debtor's alter ego. That is a very interesting doctrine that can pop up more than we think, more than you might think, even if you have your own LLC. Oftentimes, and we're not even talking about trusts, the alter ego doctrine is an equitable doctrine that can just, it can apply when you don't really think that it could. So we can mitigate the applicability of the alter ego theory by following formalities, respecting formalities, following the program. If you have a trust bank account, the account should be titled to the trust with the appropriate tax ID number, with appropriate signature authority. If one person is allowed to sign checks and serve as a signer on a trust bank account, you want that to be the right trustee. And why risk that with giving signing authority and having bank accounts, theoretically, in a trust beneficiary's name? You would want to protect the integrity of the trust, especially when you're inheriting trust property in a discretionary spendthrift trust, which traditionally is a really, really good creditor protection framework, but which needs to be set up that way at the time the trust is created, which is something you need to talk to your estate planning attorneys about. That is jeopardized when you start allowing a beneficiary to have some control, and one thing can snowball and lead to the other, and they're the investment trustee, then something gets overlooked, and somehow there's a new bank account that gets opened, and somehow it's just not titled in the name of the trust, and it just really becomes convoluted, and that really bodes well to an alter ego theory. So folks, you need to talk to your estate planning attorneys before engaging in these types of transfers or any estate planning. So talk to an estate planning and asset protection attorney in your state. Follow the program. You want to do things right, and you want to have thoughtful conversations up front. If you want to try to mitigate some risks for beneficiaries, you want your potentially even your revocable living trust to have the appropriate provisions that are triggered upon your passing in order to protect your beneficiaries as best as you can. That needs to be created in conjunction with your estate planning attorney when you're creating your trust. And in the same thing with irrevocable trusts as well, of course. But even if you think that you have a more modest estate, there are still some really customary traditional estate planning concepts that can be utilized to help maintain some potential creditor protection for your beneficiaries that with your revocable living trust in most states, isn't going to afford you as a set of law any asset protection or creditor protection. But upon your passing, maybe you want to give some protection to your trust beneficiaries. You got to design your trust with that in mind. And again, you need to talk to your estate planning attorney about that. So follow my channel, subscribe, folks, if you are so inclined. Like my channel, check out my details for my other social media accounts, and this is my contact information. Follow the program. I hope you like this program. With that, I am attorney Ryan Casson signing off here in California. I will see you next time.